The courtroom doors clicked shut behind her, and Marion Voss heard her ex-husband laugh. Not loudly. Just a short, confident exhale through his nose, the kind of laugh a man gives when he already knows how the story ends. "You're not walking out of here with anything," he murmured, leaning toward her over the gap between the tables. "Not the house, not the kids, nothing." She didn't answer. She folded her hands on the table in front of her and looked straight ahead at the empty bench, because she had learned, over 14 months of this war, that silence cost her nothing and gave him nothing to use. What neither of them knew was that 3 floors below them, in a records room nobody had checked in months, a single folder had just been found. And it was about to walk through that door in the hands of a bailiff who didn't even know yet what he was carrying. The Fairview County Courthouse smelled the way it always did in late autumn, like old radiators and burnt coffee, and the fluorescent light in Department 4 had been flickering for 3 weeks without anyone bothering to call maintenance. Marion sat at the petitioner's table in a gray blazer she'd bought specifically for this hearing, the kind of blazer that said competent and not desperate, though desperate was closer to the truth. She was 36 years old, a pediatric nurse who worked 12-hour shifts at Fairview General, and for the last 14 months she had been fighting for primary custody of her 2 children against a man who had once told her, calmly over breakfast, that he would burn every dollar he had before he let her win. That man was Daniel Voss, and he sat 11 feet away from her at the respondent's table, dressed in a navy suit that fit him better than it should have given how little he'd actually paid for it, charm being the only currency Daniel ever really invested in. He ran a small but aggressive commercial real estate firm, the kind that flipped strip malls and squeezed tenants, and he had built his entire adult identity around one belief, that the person who controlled the narrative controlled the outcome. For 14 months, he had controlled the narrative beautifully. He had hired Gerald Atkins, a divorce attorney with a reputation for turning custody battles into scorched earth, and together they had built a case so airtight, so meticulously documented, that Marion's own attorney, a tired but decent man named Robert Liu, had warned her 3 weeks ago that they might lose. Daniel's case rested on one document. A signed parenting agreement from 18 months earlier, before things had fully fallen apart, in which Marion had supposedly agreed, in writing, to a reduced custody schedule in exchange for Daniel covering the mortgage during her unpaid medical leave. It was a damning piece of paper. It made her look like a woman who had once valued money over time with her own children, and Atkins had built his entire closing argument around it, reading it aloud at the last hearing in a voice dripping with manufactured sorrow. There was only one problem. Marion had never signed that agreement. She had told Robert this on day 1, calmly and clearly, and Robert had believed her, but belief wasn't evidence, and for 14 months they had nothing to put against a notarized signature except her word. "All rise," the bailiff called, and Judge Patricia Hammond entered through the side door, reading glasses already perched on her nose, a stack of files under one arm. Judge Hammond had been on the family court bench for 19 years, and she carried herself like a woman who had stopped being surprised by people a long time ago, though she had not yet stopped being disappointed by them. She took her seat, set down her files, and looked over the top of her glasses at both tables. "We're here for the continuation of Voss versus Voss custody modification hearing," she said. "Mr. Atkins, I believe you were about to call your final witness." Gerald Atkins stood, buttoning his jacket with the smooth, unhurried confidence of a man who had already counted his victory. "Thank you, Your Honor. The respondent calls no further witnesses. We rest on the strength of Exhibit 14, the signed 2024 Parenting Modification Agreement, which clearly establishes the petitioner's own prior acknowledgement that the children's stability is best served under a reduced visitation schedule with her. We believe the court has more than sufficient grounds to make that arrangement permanent." Daniel sat back in his chair, arms loose at his sides, the posture of a man watching a play he already knew the ending to. He glanced sideways at Marion, and there was no malice in his face, which was somehow worse than malice would have been. There was only certainty. He believed completely that the system would do for him what charm and money had always done for him, smooth over the truth until it didn't matter anymore. Marion kept her eyes forward. She thought about her daughter, Lily, age 8, who had started biting her nails down to the skin since the separation began. She thought about her son, Theo, age 11, who had stopped talking about his father at all, not angrily, just quietly, the way children erase things they've decided are too painful to keep. She thought about the night 4 months ago when she had sat at her kitchen table at 2 in the morning, going through 18 months of old emails and bank statements, trying to find some thread, any thread, that would prove the agreement was a fabrication, and finding nothing but her own exhaustion staring back at her from the laptop screen. "Mr. Liu," Judge Hammond said, turning to Marion's table. "Do you have anything further?" Robert stood slowly. He had aged 5 years in the last 14 months. She could see it in the gray that had crept into his temples. "Your Honor, we maintain our position that Exhibit 14 is fraudulent. My client has been consistent and unwavering on this point since the day it was introduced. Unfortunately, we have been unable to produce conclusive forensic evidence disproving the signature within the time frame the court has allowed." It was, Marion knew, as close to a surrender as the law allowed a lawyer to make out loud. Atkins didn't even bother to hide his smile this time. "Then unless something changes," Judge Hammond said, removing her glasses and setting them on the bench, "I'm prepared to rule based on the record before me, including Exhibit 14 at the conclusion of closing arguments this afternoon." That was the moment the side door opened, not the judge's door. The other one, the one near the jury box that mostly stayed closed, the one staff used to move boxes and broken chairs, and the things nobody wanted to look at. A bailiff named Hector Reyes stepped through it, and he was not supposed to be there. Hector had worked at the Fairview County Courthouse for 11 years, mostly assigned to criminal court, and he had been pulled to department for that morning only because the regular bailiff had called in sick. He was carrying a thin manila folder, slightly water-stained at one corner, the kind of folder that had clearly spent a long time forgotten in a box somewhere. He walked up the side aisle, not rushing, not dramatic, just a man doing the small, unglamorous task someone downstairs had asked him to do. He stopped beside the bench and spoke quietly to the judge, low enough that only she could hear at first. "Your Honor, I apologize for the interruption. Records sent this up. They said it's an evidence intake file that got Mies shelved during the renovation last year. It has this case number on it." He set the folder on the edge of the bench. "They said you'd asked about a missing document a few weeks back, and this turned up in a box that wasn't supposed to still exist." The courtroom didn't go silent the way courtrooms do in movies, with a held breath and a dropped pin. It went silent the way a room goes quiet when something small and procedural happens that nobody yet understands is important. Judge Hammond frowned, the particular frown of a person whose memory has just been jogged about something she'd nearly let go of. 3 weeks earlier, almost as an afterthought during a status conference, she had asked Robert whether the original intake paperwork for Exhibit 14, the chain of custody log showing exactly when and how the document had been submitted to the court the first time, 18 months ago, during an earlier and far less contentious proceeding, had ever been located. Robert had said he'd requested it twice and been told it didn't exist. The clerk's office had shrugged. Nobody had pushed harder because nobody had expected it to matter. Judge Hammond opened the folder. Daniel's posture didn't change yet. He had no idea what was in it. Why would he? In his mind, the trial was already over. This was just the unglamorous churn of paperwork that always trailed behind a courtroom like exhaust behind a car. Atkins leaned back in his chair, checking his watch, already mentally drafting his closing remarks. Inside the folder was a single-page intake log, time-stamped and initialed from the original 2024 filing. The very first time anyone had submitted documents related to the Voss separation to the court, long before this custody battle had turned into a war. It listed every document filed that day in order by page count and description. And there, third from the bottom, was the entry for what would later become Exhibit 14. Proposed parenting schedule unsigned draft, submitted for review only. Beneath it, in a different pen in the same clerk's careful handwriting, was a notation made 9 days later. Draft returned to counsel, no execution, no notarization performed at this office. Judge Hammond read it twice. Then she looked up, not at Marion, not yet at Daniel, but at the clerk's intake log itself, as if she were making sure the ink was real. "Mr. Reyes," she said quietly, "thank you. Please have records confirm the chain of custody on this and bring me the original 2024 filing box today before we adjourn." It was Atkins who finally felt it first, the way a man feels a change in air pressure before he understands a storm is coming. He sat forward. "Your Honor, with respect, I'm not sure what's being introduced here. That document hasn't been authenticated, it hasn't been disclosed to the respondent, and frankly I'd ask the court to disregard whatever was just." "Mr. Atkins," Judge Hammond said, and her voice had not risen at all, which was somehow more unsettling than if it had. "You built your entire closing argument around a document that this court now has a contemporaneous, time-stamped record stating was an unsigned, unnotarized draft. A draft that was returned to counsel, your client's counsel 9 days after it was filed. I'm going to need you to sit down while I figure out exactly how a draft acquired a notarized signature sometime between then and now. Daniel's face did the thing faces do when certainty meets a wall it didn't know was there. It didn't crumble all at once. It just lost its color slowly like a photograph left too long in the sun. Marion did not move. She kept her hands folded on the table, the same way she had for 14 months, but something in her chest had finally, quietly, started to unclench. "Your Honor," Robert said, rising, his voice steadier than it had been in weeks, "we would ask the court for a recess to review the chain of custody documentation, and we would formally renew our objection to Exhibit 14's authenticity, with the request that the court order a forensic examination of the notary stamp and signature page against the known handwriting samples already in the record." "Granted," Judge Hammond said. "We'll recess for 90 minutes. Mr. Atkins, I'd strongly suggest you use that time to speak with your client about how an unsigned draft this court has documentation of ended up notarized." The gavel didn't even need to fall hard. The sound of it was enough to end the morning, and Daniel Voss sat very still in his expensive, ill-fitting confidence, staring at a folder he had never seen coming. The recess room assigned to Marion and Robert was a windowless office that usually belonged to a court reporter, and it smelled like stale coffee and toner. Robert closed the door, set his briefcase down, and for the first time in 14 months, Marion watched him exhale like a man putting down something heavy. "That's it," he said. "That's the thread we needed. If that intake log holds up, and there's no reason it wouldn't, it's time-stamped, it's initialed, it's a public record, then Exhibit 14 isn't just weak, it's fraudulent on its face. Someone took an unsigned draft and turned it into a signed, notarized document after the fact." "Who?" Marion asked, though she already suspected. "That's what the forensic examiner is going to tell us in the next 90 minutes, Robert said. "But Marion, I want you to understand what this means even before we get that answer. The entire foundation of his case just turned to ash. A judge doesn't forget being handed evidence that the other side's star exhibit might be forged. Hammond is not going to let this go quietly." Marion sat down slowly in the cracked vinyl chair across from him. 14 months of 2 a.m. panic, of being looked at by her own children with confusion when she couldn't explain why Daddy kept saying things in front of the lawyers that weren't true, of doubting her own memory because a piece of paper with her name on it had been staring back at her in a courtroom. All of it collapsed into something she hadn't let herself feel in over a year. Not triumph yet. Just the smallest, most fragile kind of relief, the kind that doesn't trust itself enough to celebrate. "I need you to do one more thing for me," Robert said. "When we go back in, whatever happens, whatever he says, you let me handle it. Don't react. We're not done. We're close, but a wounded man like Daniel doesn't go down quiet." He was right. In a separate conference room down the hall, Daniel Voss was not handling it quietly at all. "Find out who pulled that file," he hissed at Atkins, pacing the small space like a man trying to outrun a verdict that hadn't even been read yet. "Someone in that records office made a mistake, and we are going to bury them in motions until this disappears." "Daniel," Atkins's voice had lost its courtroom polish entirely. "There is a time-stamped public record showing that document was an unsigned draft. That's not something we bury. That's something the state bar reads with great interest, depending on how that notary stamp got there." Daniel stopped pacing. "What are you saying?" "I'm saying," Atkins said carefully, "that you told me 18 months ago this document was legitimate. My office notarized a signature page on your representation that Marion had signed it in front of you. If it turns out that page was added later, I need you to tell me right now, before that judge calls us back in, exactly what happened. Because I am not going down with you on a forgery charge over a custody case." Daniel didn't answer. He sat down heavily in one of the chairs, and for the first time in 14 months, the calculation behind his eyes wasn't aimed at Marion. It was aimed at his own exposure, and it terrified him far more than she ever had. When the courtroom reconvened 90 minutes later, the air had changed in the particular way air changes when everyone in the room has heard a rumor but nobody has confirmed it yet. The forensic document examiner, a soft-spoken woman named Dr. Elaine Park, who had been on standby for exactly this kind of emergency request, was sworn in within the first 10 minutes. "Dr. Park," Robert said, "you were asked to compare the signature on Exhibit 14 against the petitioner's known signature samples already in this court's record, correct?" "That's correct." "And what did you find?" "The signature on Exhibit 14 shares structural similarities with the petitioner's known signature, but the ink composition does not match the ink used on the rest of the document. Using infrared reflectography, I was able to determine that the signature line and the notary stamp were both added to the page significantly later than the body text. At minimum, several months later, based on ink aging characteristics. The notary's own date stamp, when cross-referenced with the notary's office logbook, does not correspond to any entry for a Marion Voss appointment on that date. The room held its breath. Daniel's leg had begun, almost imperceptibly, to bounce under the table. "In your professional opinion," Robert asked, "is it possible that this document was an unsigned draft that had a signature and notary stamp added to it after the fact, without the petitioner's knowledge or consent?" "In my professional opinion," Dr. Park said, "that is not only possible. Given the evidence, it's the most probable explanation." Judge Hammond did not raise her voice. She didn't need to anymore. The room had already turned itself toward her, waiting. "Mr. Atkins," she said, "I am going to ask you a direct question, and I want you to think very carefully before you answer it, because everything that comes after this hearing depends on your answer being truthful. Did you or anyone in your office notarize a signature on this document that you did not personally witness Marion Voss execute?" Atkins stood slowly. He looked, for the first time in 14 months, like a man calculating not how to win, but how much he had left to lose. "Your Honor," he said, "I'd like to consult with counsel before my client or I respond further." "That request is granted," Hammond said, "for exactly 5 minutes. After that, I expect an answer on the record, because right now what I have in front of me is evidence of a forged custody document submitted to this court 18 months ago, and that is not a family law matter anymore. That's a referral to the district attorney's office and the state bar." The 5 minutes that followed felt to Marion like the longest of the entire 14 months. She did not look at Daniel. She didn't need to. She could feel, even without looking, the exact moment his certainty finished collapsing, the small shift in the air of a man who has spent his whole life believing charm could outrun consequences, finally understanding that this time it couldn't. When the room reconvened, it was not Atkins who spoke first. It was Daniel, rising on his own against his attorney's whispered objection, his voice smaller than Marion had heard it in years. "Your Honor, I'd like to make a statement. My attorney's office didn't forge anything. I did. I took the draft after Marion moved out, had her old assistant, who I was paying, forge the signature, and paid a notary I knew personally to backdate the stamp. I told my attorney it was legitimate." He swallowed. "I thought if I just controlled the paperwork, none of it would ever actually matter." Judge Hammond let the silence sit for a long moment before she spoke again. "Mr. Voss, it mattered a great deal. It nearly cost your children's mother 14 months of her relationship with them, based on a piece of paper you manufactured out of thin air. I am terminating these proceedings on Exhibit 14 with prejudice, referring this matter to the district attorney's office for prosecution under this state's forgery and fraud upon the court statutes, and I am ordering a full evidentiary hearing to reassess this entire custody matter, this time without a single fabricated document anywhere near my bench." The consequences arrived faster than Marion expected, and far more completely. Within a week, the district attorney's office had filed charges against Daniel for forgery and fraud upon the court, charges that carried real prison time in that state given the deliberate, premeditated nature of what he'd done. His business partners, already uneasy about his erratic behavior over the past year, quietly began extracting themselves from his real estate firm before the headlines could touch their names too. The notary who had backdated the stamp lost her commission entirely and was charged as an accessory. Atkins, though he hadn't known about the forgery itself, was referred to the state bar for failing to verify a document he should have scrutinized far more carefully before staking an entire case on it, and he quietly stopped taking new custody clients within the year. The reassessment hearing, 3 months later, was almost anticlimactic in its calm. Judge Hammond reviewed the actual record, the real one, the one built on Marion's consistent work schedule, her unbroken history of school pickups and pediatrician visits, the testimony of Lily's second-grade teacher about who showed up to every parent conference, and Theo's quiet, careful words to a court-appointed counselor about wanting things to go back to feeling normal. There was no theater to it. There didn't need to be. The truth, once it was finally allowed into the room without a forged document standing in front of it, did most of the work on its own. "The court awards primary physical custody to the petitioner," Judge Hammond said, "with supervised visitation for the respondent pending the outcome of his criminal proceedings, to be reassessed thereafter based on his compliance and his children's well-being." Marion didn't cry in the courtroom. She had promised herself, somewhere around month 9 of this fight, that she wouldn't give anyone in that building the satisfaction of watching her break, and she kept that promise even now, even in victory. She cried later in the parking lot, sitting in her car with the engine off, her hands shaking against the steering wheel, the same hands that had stayed perfectly still on a table for 14 months. 6 months after that, on a Saturday afternoon thick with the smell of cut grass, Marion sat on her back porch and watched Lily teach herself to braid a friendship bracelet, her nails finally growing back, no longer bitten to the skin. Theo had started talking about his father again, carefully in small pieces, the way children do when they're slowly deciding the world is safe enough to ask questions in again. There was no fairy tale reconciliation. Daniel was serving an 18-month sentence and would carry a felony record for the rest of his life, a consequence built entirely and only by his own hand. But there was something quieter and more durable than revenge sitting on that porch, something that had taken 14 months, one Mies shelved folder, and one bailiff doing an unremarkable errand to finally arrive. She had been told she would never win in that courtroom. What no one had accounted for was that the truth doesn't need to be allowed to survive being buried. It only needs one door to open at the right time. If this story of patience, truth, and a justice system that finally got it right hit home for you, make sure to like this video and share it with someone who needs a reminder that the truth has a way of surfacing when you least expect it. And if you want more stories like Marion's, subscribe and turn on notifications so you never miss the next one.